Hello everyone, this is Civil Litigation and Evidence Chapter 1, which is General Matters, and there are two questions on the exam from this topic. To identify where a civil claim goes, whether it goes to the county court or a high court, it is completely dependent on the nature of the claim and the financial value of the claim. Firstly, we will talk about the nature of a civil claim. There are two types. First is a personal injury claim, and the second type is a non-personal injury claim. We will be looking at the financial values within each of the types to identify where the claim must go and where there is a choice of where the claim could go. So personal injury claim, obviously it includes road traffic accidents and other sorts of injuries. And non-personal injury claim includes tort, contract, and other types of claims, which you must have studied in tort and contract, including negligence, oral and written contracts as well. So first we will be looking at the personal injury claims. If the claim value is less than 50,000, then the claim it must go to the county court. There is no option. It must definitely go to the county court if the claim value of personal injury claim is less than 50,000 pounds. If, let's say, the claim value is of a personal injury claim is above 50,000 or is exactly 50,000 pounds or above 50,000 pounds, then you have a choice. Now, what does that choice includes? That the claimant can either choose county court or it can choose high court. So, if there is an MCQ in the exam, you must look for the word may go to county court or high court when the value of the claim is exact 50,000 or more. Now there are certain factors which the court will consider and the claimant has to prove to the court to take the claim to high court with a claim value of 50,000 or more. There are three factors. Number one, the financial value of the claim. So the claimant has to prove to the court that the financial value of the claim is high enough to go to the high court. And so this is an or situation. The other factor that the claimant can show to the court is that the case is of a complex nature. It could be a very complex case. It involves a lot of factors, a lot of pointers in it, a lot of issues. And the third factor is that the case holds public importance. So as we know that high court judgment is binding, so if the case holds a public importance, then it may go to high court, and as a claimant you have to justify it to the high court. These are three factors. You can prove any one of them, or you can prove all of them, or you can prove two of them to the high court to justify that your claim should go to the high court. Now let's consider the non-personal injury claims, which definitely includes tort and contract claims. If the claim value of a non-personal injury claim is less than 100,000 pounds, then it must go to county court. So let's say if the claim is exactly 100,000 pounds or is less than 100,000 pounds, it must go to county court. If the claim value is more than 100,000 pounds, then it may go to county court or high court. So there comes a choice. And again, this is same as we did in the personal injury claims, that you have a choice and there are three factors that apply. So similarly, the same factors would apply here: the financial importance of the claim, the complexity of the claim, the public importance of the claim, and you can prove all of them to the High Court, or you can prove at least one of them to the High Court. So this is a situation that you just don't have to justify it to the High Court, you can also justify it to the County Court as well. So in both situations, in PI or non-PI claims, you have to show these factors to County Court or High Court to exercise the choice. Also, another point that if the financial value, if there is no financial value of the claim, then you must consider the complexity of the claim or the public importance of the claim to identify where the claim should go. The second thing we would consider is how to calculate the financial value of a claim. So to calculate the financial value, you always disregard the cost, which includes all the expenses of a claim, including court fee, witness expense, expert expense, or any other expense or cost in terms of application, interim application, that comes under the ambit of cost. And the interest of the claim, you disregard the counterclaim, and you disregard the contributory negligence. Now, contributory negligence, if it is admitted, then you consider it, and you also disregard social security benefits. So there are 5 things that you disregard when calculating the financial value, which you take 5 things that you do not consider in your financial value of the claim is cost, interest, counterclaim, contributory negligence, and social security benefits. But if contributory negligence is admitted, that will be taken into account to calculate the financial value. Now we come to another part of this topic, which is what if you send your claim to a wrong court. Now, there are 2 things that can be done. Let's say if the claim was supposed to go to High Court and you send it to County Court, or it was supposed to go to County Court and you send it to High Court, then there are 2 things which can be done. The first, you can transfer the claim to the correct court, or you can, if the wrong court is High Court, then it depends if the High Court is accepting the claim or is rejecting the jurisdiction of the claim. So let's say if you file the claim in the wrong court, so to transfer it to the right court, there is a transfer fee that is applicable, that is imposed on the claimant for filing the claim in the wrong court. And if the wrong court is High Court and they accept the jurisdiction, they accept the claim as it is, and they carry it forward, and if the claimant won the case, then the court can impose a 25% cost reduction on amount that is awarded to the claimant. So in the final financial value that is being awarded to the claimant, the court has the discretion, the complete discretion, to impose a 25% reduction in that award. And this reduction can obviously be imposed only if the claimant has won the case. So High Court has a discretion if the wrong court is High Court. Now we move forward to the process of how to file a claim. That completely depends in which court your claim is going, your civil claim is going. So if your claim is going to a county court, if you have identified the financial value of the claim, now you decide to file the claim, and you see that the claim goes to the county court, then there are a few methods. So there are 3 ways in which a claim can go to the county court. It depends whether the claim is money claim, whether the claim is non-monetary money claim, non-money claim like injunction, whether the claim is online money claim. So if the claim is money claim, then it is dealt with centrally or it is dealt with online. If the claim is non-monetary, then there is no option of dealing it online. So if the money claim is being dealt with centrally, so the claimant issues the claim form at Civil National Business Center, and the National Business Center then informs the defendant of the civil claim, and then the defendant, they file their defense in the Civil National Business Center, and then the Civil National Business Center then will send parties to County Court Hearing Center, as in they will allocate a County Court Hearing Center for the claim. So this is how a county court money claim is dealt with centrally in a Civil National Business Center. But if the county court is being dealt with online, so it is a simple procedure that it is being dealt with on a website where the claimant files their claim form, and then the defendant, they responds to the claimant online, and then on the website the county court hearing center will be allocated to them. But this option has conditions. This is a conditional option. You can only file a county court money claim online if these two conditions are being satisfied. Number one, that there are two or less defendants, and that the claim value is less than £100,000 or exact £100,000. So these two conditions should be met. Now, why would a defendant consider an online money claim in the county court? Because it is quick, it is efficient, it is cost saving. So these are the factors that a claimant would consider in filing a claim in an online money claim. Then there is another option, which is when the claim is a non-monetary claim, such as an injunction. If a claimant is asking for an injunction from the court, then they simply just file their civil claim in any county court hearing center of the UK. It could be any county court hearing center of the UK. Within UK, it could be any county court hearing center. It is a very simple procedure. Then we move forward to how a claim is filed what is the process of filing a claim in High Court. So for High Court, it is pretty simple. For a High Court, you could either file your claim within London, or you can file the claim outside London. So as we've looked at the county court procedure, that to file a claim in a county court, if your value is less than 50,000 or above 50,000, or if it is less than 100,000 or exact 100,000, it goes to county court. But for High Court, for county court, the procedure is a bit lengthy, but for High Court, it is simple. That if your claim is in London, you want to file it in London, you go to the Royal Court of Justice. But if your claim is outside London, then the claimant has a full discretion that they can either file it with the district registry of the High Court, or they can go to the Royal Courts of Justice in London. So here the claimant has a discretion to file the claim in any High Court, within or outside London in the UK. Now we will be looking at the overriding objective, which is the last part of this topic, general matters. It is pretty simple, and it is one thing that is recommended to keep in mind throughout the whole civil claim, throughout your exam. That overriding objective is a very important principle that is being applied by the courts, by the parties, by everyone involved in a claim throughout the claim. This is something that both the parties need to consider in mind, the court needs to consider in mind. So there is the first factor is that the claim should be managed in a just and proportionate way, which includes that the parties in the court must be mindful of the time, the court's resources, the parties' expenses, um, and they both have a duty of actively managing the claim. So, for the parties, they have to at least narrow down the issues in terms of ADR or through settlement. ADR is alternate dispute resolution. The parties can either follow ADR methods or can go for settlement, or if they cannot carry forward that alternate dispute resolution, they can simply narrow down the issues. For court, they have to be mindful of managing the case in just and proportionate manner, keeping in mind the expenses of both the parties and their positioning in the case. It is on the parties to also explore the alternate dispute resolution methods. It is very important. The court cannot compel a party to follow, but it can only encourage parties to follow ADR methods. Parties are supposed to cooperate, as in they do not have to, by cooperation, it does not mean that they have to remind the other party of the dates or the deadlines of a particular submission or a particular application or a particular exchange of documents. Rather, they have to cooperate and keep a full coordination, because both of their conduct is being considered by the court in terms of their cost. So, both the parties should be kept on equal footing in terms of overriding objectives. So now, just to recap that to identify where the court goes, high court or county court, depends on the nature and the financial value of the claim. It's a PI claim. If it's less than 50,000, it must go to county court. Above 50,000 or exact 50,000 may go to county court. Financial value, complexity of the case, and public importance is to be kept in mind when applying to the high court and county court for the financial claim. For the non-PI claim, the amount is exact 100,000 or less than 100,000. It must go to county court, or above 100,000 may go to county court. Three factors apply to calculate the cost. There are five things that needs to be disregarded, including cost, interest, counterclaim, contributory negligence, unless admitted, and social security benefits. If the claim goes to the wrong court, either you can transfer the claim or the high court can accept its jurisdiction. And discretion is always with the court. If the high court accepts the jurisdiction and the claim is won, then the court can impose 25% of the reduction in the amount that is awarded. To file a claim in the county court, there is money claim, which can be done centrally in CNBC, which is Civil National Business Center, or it can be done online through the website. If you file your money claim centrally, it has to be Civil National Business Center, where they allocate a county court hearing center. And if it is online, it has to be on the website, where two conditions apply: that there are to be two or less than two defendants in a claim, and the claim value is to be less than 100,000 pounds or exact 100,000 pounds. If it's a non-money claim, it could include injunction, and the claimant can file the claim in any county court hearing within the UK. It goes to High Court, simple. Within London, you can go to Royal Court of Justice. Outside London, you can go to District Registry of High Court. But at the end of the day, it is always the claimant's discretion where they want to file their claim. So this is topic 2. Topic 1. Thank you.